Florida attorney L. Reed Bloodworth is the managing partner of Bloodworth Law with offices in Orlando and Winter Haven, Florida. Bloodworth Law handles employment litigation for Florida employers facing federal and state legal disputes with employees on a range of issues. Bloodworth Law partner and employment litigation attorney J. Kemp shares insights on a common concern for Florida employers when it comes to proving harassment or discrimination in a Florida workplace. Kemp said he strongly discourages anyone from ever recording people in any situation on a hidden camera or audio device. It is a crime in Florida. "You don't want to record someone secretly," said Kemp, who was a 2019 to 2022 super lawyer for his work in employment law. "That's not a good idea. It never is." Attorney Brinson explains that Florida statutes make it a crime to secretly record someone under circumstances where that person has a reasonable expectation of privacy. Whether a conversation at work is under the circumstances creating a reasonable expectation of privacy or not, it is something that could be litigated, and it is not usually a risk you want to take. And in regard to harassment or discrimination in the workplace, Kemp said, one comment isn't going to be actionable. But I can think of a few aspects that might be actionable alone, and here are 3 examples. First, if a person's supervisor were to overtly demand sex as a condition of keeping one's job, that statement alone might be considered actionable, Kemp said. Second, I could also imagine a situation in which a threat of firing is communicated if an employee does not conform to particular gender, racial, or other protected norms would be actionable. Third, a demand would probably have to be some sort of threat or quid pro quo, which is a favor or advantage granted or expected in return for something, to be actionable, Kemp said. Generally, creation of a hostile work environment is going to require comments that are both severe and frequent, Kemp said. Kemp explained that the type of comment that would be actionable legally would be extremely egregious. And if you had, in and of itself, that one thing, it is the only thing you got. And if you don't have proof that it happened, that would be a really hard case, he said. Typically, we're going to be talking about a situation, if we're talking about comments, where if it's anything close to a viable claim, we're going to have comment after comment after comment after comment after comment over time. Number 1. It's going to be a cultural problem in the workplace. Number 2, there's going to be 6 perpetrators, not 1. Number 3, it's not going to be a simple he said, she said, Kemp explained. Number 4, it's going to be more like, yes, I acknowledge we were kind of potty mouths, but it's not as bad as they're saying type of situation, Kemp said. But then you can throw them all in front of a jury, and the jury can decide who to believe. Whether you're an employer defending against harassment claims or an employee making discrimination claims, Kemp said that proving harassment or discrimination in a Florida workplace is complicated. Every case and each client's circumstance is unique. Talk with attorney L. Reed Bloodworth and attorney J. Kemp and the employment law team to find out how Bloodworth Law can help you, your employees, or your business.